Our presenters today are attorney Geraldine P. McEvoy. She's a founding attorney partner of McEvoy and Stuntz LLP in Concord, Mass. As a family law practitioner for over 20 years, Attorney McEvoy is a mediator, guardian ad litem, volunteer conciliator with the Middlesex Bar Association, and she has served as both a discovery and property master. Geraldine takes great joy in helping people navigate the uncertainty of divorce and envisioning the life post-divorce. And we also have attorney Cathleen Summers. Cathleen is one of our founding attorneys with over 30 years of legal experience. Cathleen concentrates her legal practice on estate planning, crisis planning, Medicaid and long-term care planning, and guardianship. She's the go-to expert on helping clients and their families navigate the legal and healthcare worlds in a crisis. Kathleen is often sought out by professionals to serve as an advisor to local hospitals and to be a member of boards in the community. She currently serves as the president-elect of the Massachusetts chapter of the National Academy of Elder Law Attorneys. So thank you, Kathleen and Geraldine, for joining us today, and I'll turn it over to you.
Well, everyone, thank you. We're going to actually talk about a little bit more than just estate planning after divorce. We're going to talk about estate planning throughout the divorce process and talk about what the different estate planning documents are for. So let's start with just talking about what happens before you go ahead and file for divorce. So this is at the point where you're contemplating a divorce proceeding, and some of the things that you can think about in terms of your estate planning considerations. One of the things I want to remind everybody of is that until the divorce is final, your spouse, from a legal standpoint, is still considered your spouse, and a spouse has certain rights under the law to be able to claim a portion of their spouse's estate. So those legal requirements remain in effect until the divorce is finalized. But a couple of things that you can think about, again, before you've gone ahead and filed for divorce. Remember, number one, you really want to do all of these things in consult with a divorce attorney, with a family law specialist such as Jerry, to make sure that you are doing things appropriately and that you're not going to be subject to the courts looking at your actions and reversing them after you've done them. But you really should look at your current estate planning documents if you have things in place. And one of the big areas that you can make changes in prior to filing for a divorce is who you have named as the important decision maker in some of these documents. So for instance, in your durable power of attorney and your healthcare related documents, and I'm going to go through these documents with you at the end of the presentation, but when we're talking about a durable power of attorney in which you're giving someone the ability to step into your shoes for financial, for the most part, decision making, and your healthcare decision making documents in which you're asking someone to step into your shoes if necessary for healthcare decisions, these things you can and should change should you not want your soon-to-be or future ex to be the one who's making those kinds of decisions for you. So absolutely want to take a look at your current estate plan. And if you don't have a current estate plan in place, you want to get these documents in place and name the individuals that you want in those important decision-making capacities there to be able to make the decisions for you. Jerry, I know that you're going to talk a lot about what happens after divorce is filed, and there's specific, particularly under the restraining orders that occur automatically. But at this point where we're talking about pre-filing, are there considerations that you have suggested to your clients to think about?
From an estate planning perspective, I think you hit the nail on the head with regard to having the durable power of attorney and the healthcare proxy in terms of whether their current spouse is listed as a beneficiary, you definitely want to change those. And there won't be any repercussions for changing those when you are in the midst of a divorce. I don't think anybody wants well, I would say most people don't want the person you're getting divorced from making decisions about your health when, unfortunately things may not be going well for you, and you don't want them having that decision-making power, because obviously they have their own agenda at that point. But I think it's important to if you're in the pre-planning phase, and I just want to mention to the listeners that pre-planning can happen years before you actually decide to go the divorce route. I have a lot of parents that want to wait until certain milestones in their children's lives are reached before they dissolve the marriage. They think sometimes it's in the children's best interest to remain married until, say, a child graduates from high school or graduates from college. But I have people that come to me and consult with me sometimes 3-4 years before they're ready to file for divorce. And those are the conversations where you just want to impress upon people how important it is to know what your estate planning documents say. Sometimes couples go to a lawyer and they have their estate plan drawn up and they just sign on the dotted line, and they don't really understand the documents that they're signing. And I think it's very important to educate yourself during the pre-planning phase, because there may be a trust you signed and you no longer want that in place. Different things occur during different phases in your life. What worked for you once may not work for you later on. So I think a lot of people feel secure when they have a will in place or a trust in place that, oh, well, that's done. But it's not, it needs to be looked at again. So back to other things that you can change. Typically, you can change the beneficiary on your life insurance and your other accounts that have beneficiaries. However, I would do that before the divorce, not after. You can't do it during the divorce, because we'll get to the automatic restraining order that goes into effect once one party files for divorce. Your hands do get tied at that point, and you cannot make those changes. I will say, as an aside, though, that probably one of the first things your spouse's attorney will want to see who the beneficiaries are when the divorce starts. So the court may, if there's a support obligation or the assets have not been divided yet, you may need to change them back to your spouse during the pendency of divorce until everything is final.
And another thing regarding beneficial designations as well, particularly retirement plans do have limitations on how you can change the beneficiaries. For instance, in Massachusetts, your spouse has a right to a retirement plan and must actually sign off and forego that right if you're taking them off as a beneficiary. So, knowing that and potentially changing what you can, with the thought that it may need to be changed back depending on the terms of the divorce agreement or what if there is an issue that arises, at least getting those things in place. And as Jerry said, really understanding your estate and your current estate plan before you file is critical, because she's absolutely correct. Things that you put in place, when you were first married or when you have young children made perfect sense at that time, but things change. And as they change, we want to make sure that estate plan is thoroughly reviewed to make sure it's reflecting what's happening. The other thing, Jerry, I know that, has oftentimes happened is sometimes people don't have a good understanding of what their estate really means. What exactly are their asset holdings, whether it be individual asset holdings, joint asset holdings, the properties that they own, et cetera. And when you talk about people who come to see you even a few years before they actually may start divorce proceedings, that's another opportunity, again, to really get your hands around what is the estate? What is really involved?
Right.
Yeah. So take the time now, if you are in a pre-divorce situation, to take a look at things, understand what's involved in terms of the value of your estate, what assets are being a part of the estate, and what your current estate plan says if you have something in place. If you don't have something in place, again, this is a critical time to get certain documents, particularly powers of attorney, healthcare related documents, because life happens and we don't have the crystal ball. And if something were to happen to your ability to manage things for yourself during this time frame, you want to make sure the people or the person or people that you want in that important decision-making capacity are there. Right. So why don't we go ahead and move forward and talk about what happens while the divorce, after the divorce has been filed and the case is pending with the courts.
So once the divorce is filed, part of you have to notify the other party, which is done by serving the complaint for divorce with a summons. And the summons has this language that you see on the screen right on it, basically saying that you cannot take any unilateral actions with regard to funds, transferring funds beyond the reach of the court, or, giving your buddy a $20,000 check just to hold for you. Anything that is in the marital estate, whether it's held individually or jointly, you need to maintain the status quo, and the larger purchases need to be agreed upon with the other parties. You cannot change any beneficiaries of your life insurance, pension or retirement plan, and investment accounts, except with the written consent of the other party or order of the court. You're also not even allowed to change anything with regard to the life insurance policy, medical, dental, life, automobile, and disability insurance. So nobody can, during the pendency of a divorce, just decide, I don't want to cover my wife on medical insurance anymore. I'm going to make that change. No, you cannot do that. This is known as Rule 411. That would be a Rule 411 violation, and you could be held in contempt of court for doing that. Now, it's not really as draconian as it sounds. I mean, a lot of these times, if something comes up during the divorce that you need to change, the other side, you can get the other party to either agree to it, or you can file with the court to ask the court for permission. And the court, if it's a situation that makes sense, the court will most times allow you to do what it is that you need to do. The court, there is an exception in the first paragraph that says that you can do these transactions in the ordinary and usual course of business. How you've been practicing prior to the divorce, you can continue to do that without the court getting involved and without being in violation of this order. You can also use funds to pay your attorney, reasonable attorney's fees and cost, and for your usual living expenses. So the court's not going to make you get an order from the court if you need access to funds for your normal living expenses. And that means, your food, shelter, maintenance, that type of thing. So this is something that automatically goes into place. So if you are planning, and sometimes I meet with clients before we file, and that's the time. If your car is, if you need a new car, you want to refinance, even if you want to just finance the car or refinance the house before you get divorced, is the best time to do it. Otherwise, you could either be tied up. Like the court could say, no, that's not an emergency. You don't need to do that right now. Let's wait. or the other side may not agree, which would mean that you'd have to go to the court. So to make it easier, you should do it before you go to before you file for divorce.
Right. So absolutely, the actual filing of the action really does set into motion these restrictions, and doing as much as you can prior to that is really critical. And again, working with your, your family law attorney to make sure that the actions that you're taking are within the parameters, and having all of that done, even thinking about things. And Jerry, I think that's a great example of, you need a new car, you've got an issue. You don't want that to be something that is held up because you're now in a divorce proceeding. So really thinking about those things ahead of time and getting the ducks in a row before you file is critical. And we both know the courts move really slow these days in particular, and it's brutal, I'm sure. And I'm sure on your end, you're seeing a lot of delay in getting some of these things resolved.
There's so many delays, and some things that have happened recently that I'm a little surprised about, but not, I guess I'm disappointed, but not surprised, is one spouse wants to take advantage of the very, very active real estate market and wants to sell now because they know that this is the time to sell because of the prices and how things are moving. But the court will not order it if you're in the middle of a divorce unless there's some egregious circumstances, like unless you can't, one party isn't working and they can't pay the mortgage. But in the middle of a divorce, the court is very unlikely to order the disposition of certain assets until the end. So I've had 2 or 3 clients that have not been able to sell the house during this market because the other side doesn't agree.
I have a question for you guys. Someone is asking, isn't mediation better than court?
I will answer that with an unequivocal yes. Going to court, I say, is a last resort. Okay. So saying that mediation is a voluntary process where both parties have to want to get divorced. They want to work it out with a mediator. Each party has access to the other party's finances, because without knowing the full picture, mediation may not be appropriate for you. Now, a mediator is somebody who facilitates an agreement that's going to be fair and reasonable, and the court is going to accept it. However, the mediator doesn't represent either party. So what I usually recommend to people is that they spend the hour or 2 in legal fees with an attorney who's going to be coaching you in the background and helping you make these decisions, because once you make them and sign an agreement, that's what you're stuck with. So, I have a lot of people, I've experienced people that just want to get it done, and they will go to a mediator and sign an agreement where the other party has had more information and is the stronger party in terms of knowing the finances, and spending that $350 and having an attorney look at the agreement to make sure that your rights are being protected is vital. But I do think mediation is an excellent way to navigate the divorce. You have more say in the final outcome of your case. You don't want to just be handing your life over to a person in a black robe that has been, that doesn't know you all that well. Trials are very expensive, and they're very emotionally taxing. However, at the end of the day, sometimes that's the only way things can be resolved, because you just can't come to an agreement. But I personally think mediation is is an excellent way to dissolve the divorce. But again, it really depends on the facts of the case.
But as you also said, Jerry, to be able to have your own independent counsel who is in the background, making sure that you're understanding the ramifications of the things that you're agreeing to. If you have questions about, about what your rights are, et cetera, that can be very valuable too, even with the mediation process.
Right. Because there's legal implications that a layperson may not understand and, believes they understand the language. And it's not the mediator's job to educate you. That would not, the mediators are neutral, and it would not be fair for the mediator to explain the law to the client. Basically giving a framework of what the court would find acceptable is different than saying what is best for you, because that wouldn't be being a neutral if the party gives information to one party.
So why don't we now go ahead and move forward and talk about what really you should be concentrating on in terms of your estate planning after your divorce is finalized. And again, one of the big things I think everyone doesn't realize, and Jerry, I don't know if you see this, is that the divorce isn't final when the judgment has been entered. There is a time frame before the divorce is actually final, correct?
Correct. Generally, so there's two ways that you can get divorced. You either get divorced pursuant to an agreement, which becomes a judgment of the court, or you get divorced pursuant to a judgment that the court gives you. Both are then subject to the nice-side period, which is the 30-day period between the date of your divorce, which is the day you actually submit the agreement and the court accepts it, or the date that the judgment comes down from the court. So from that date until 30 days later, you're in the nice-side period, which is kind of the limbo period, right? I believe that it was put into place so that people could change their minds. And you don't see people doing that very often after what they've just been through to get that date, to then say, okay, I did not, we don't want to go through with this. So during that period, you're not divorced.
Right.
It's kind of funny. You're divorced, but you're not divorced, right? Like
Right.
you're in that limbo period. So after the nice-side period, so that's the first 30 days. It's not until 90 days after the court accepts your agreement or gives down a judgment that the judgment is absolute, meaning, okay, that's it, it's final. However, if there's two different ways to file divorce, there's contested or uncontested. If you file an uncontested divorce, meaning that you and your spouse file together, there's no plaintiff or defendant, your co-petitioners, you file everything together, it's an uncontested divorce, then you're divorced 120 days after you submit the agreement. Does that make sense? I know it's a little confusing.
I think though and thank you for that, because it is confusing, and I think it's very confusing for people involved in all of this as well. But from an estate planning standpoint, one of the important things to remember is that until the divorce is final, and that is after either the 90 or 120-day period of time, that your now ex-spouse actually still has legal rights to an aspect of your estate. And so again, we have seen where an individual will pass away during this time frame. And again, none of us has the crystal ball to know what life holds for us. And so it's really important that that be considered in terms of your estate planning. Again, making sure if you didn't do it before, which is really where we recommend that you do, but at this point, without question, make sure that you've got your estate planning documents updated. Get those durable powers of attorney and those healthcare related documents updated without question, so that you have the person or people that you want to be in those important fiduciary positions to make decisions for you should you not be able to do so for yourself. If you had trust, as Jerry had mentioned earlier, oftentimes we do estate planning at certain points of our lives, and maybe we put a trust in years ago, and, making sure that we had certain named individuals to be the guardians of our minor children. You want to take a look at all of those things again, because let's say you chose your former brother-in-law and his wife to be the guardian of your children 10 years ago, and now children are still minors, but do you really want what is now part of your ex-spouse's family to be the ones who would step in as guardian? You may be perfectly fine with that outcome should it come to pass, but you really want to look at that situation and be sure that you have been clear about who your choice is should something happen to you. Your trust, things that you put in place originally. When we are dealing with a married couple, we have specific benefits that come with that around particularly taxes. And that tax savings language is no longer going to provide the same benefit to you. So you want to make sure that you're looking at your documents again from even a tax planning standpoint, and that you understand the implications of now planning for post-divorce situations regarding taxes and how that will all work. So looking at those estate planning documents, and Jerry, maybe you can speak a little bit to the fact that you now have a divorce agreement in place and how that might impact any future estate planning that you do.
So
and think
do you
about
mean
life
that
insurance, like life insurance. Oftentimes I see in divorce agreements around how maintenance of life insurance policies and beneficial interests under life insurance policies that are part of a divorce agreement that we have to make sure are properly reflected in an estate plan?
Sure. So many times if there's a child support order or an alimony order, in order to secure that obligation, the court will order that the parties have a life insurance plan in place in order to help support the dependent party or child in the event of the payor's death. However, it's important to take a look at your documents, your life insurance documents, to make sure that you're not leaving more than is required by the agreement, and that you have clearly defined who the beneficiaries are. Typically, the court will require that you, in the case of a child support order, the court will require that you name the other parent as the beneficiary for the benefit of the child. And the same thing for an alimony order. You have to name the other party that would have been paid alimony in the event of your death. But it's important to make sure that if you have a policy that's larger than the amount that you're ordered to pay for that individual, that you clearly define who the different beneficiaries are going to be.
That's a great point to bring up, Jerry. We actually were dealing with a client recently who had $1 million life insurance policy, had 3 children, and under the agreement had agreed that $750,000 of that life insurance policy would go to his ex-spouse should he pass away before the children hit certain ages. So one of the things too is that as each of the children were aging out of that requirement, it gave him then the flexibility to be able to adjust the beneficial interest, so that if something happens to him and 2 of his children now no longer are covered by that agreement, his ex-spouse isn't getting $750,000, but adjusting that down to the $250,000 that was required by the agreement. So critical that that be looked at. The other thing we've seen, Jerry, and I don't know if you can speak to this, is, there's a requirement under the court order to maintain the life insurance, but sometimes we see people don't follow through with what they're supposed to do. And, then you have an untimely death of someone, the life insurance policy has either lapsed or the beneficial interest is listed to someone else. And that can get very messy. And correct me if I'm wrong, but particularly in the case where there's been a lapse, there may be no recourse.
Right. And that's why we usually put language into that section of our agreement that says if the life insurance is either not in place or does not name our client as beneficiary, that client will automatically become the estate will be obligated to make that party whole. That language is very important, because I think it's important for people to realize that life insurance is a contract. So if you name your ex-spouse as the beneficiary, the life insurance company really doesn't care what your divorce agreement says. If you make the mistake of not changing it, or if there is no provision that once the children are emancipated, that you no longer have an obligation to cover that party under the life insurance, you have to make the change with the life insurance company. They're not going to take the language of your agreement. They've agreed with the party that they're providing the life insurance coverage for, that this is who they're going to pay upon your death. And like you said, it becomes very messy if you don't do that. They're two separate contracts, right? There's your separation agreement, and then there's the life insurance policy, and you have to communicate with the life insurance company to tell them who you want the beneficiary to be.
So I think there's a couple of really important takeaways here. One is to remember your divorce agreement, your separation agreement through all of this has impact in terms of your estate plan, and you need to make sure that what you're doing within your estate plan meets the requirements under that separation agreement as well, or takes into consideration requirements under that separation agreement. And also that, you consider things, as Jerry said, that, people don't always do what they're supposed to do. So what's the fallback position, and making sure that's part of the separation agreement if you're counting on the fact that your ex-spouse is going to be providing for you under a beneficial interest in their under their life insurance policy. And then again, really looking at your own estate plan to make sure that it meets the requirements of that separation agreement, but that it also reflects your now new normal in terms of what your wishes are, and in terms of how you want to see things handled, and who you want to have handle them, and how you want things distributed should you, or upon your death, or should you become incompetent or incapacitated for any reason. So critical things to think about, because all of these things have some major ramifications, and how you think things will go isn't always how they do. And so making sure you're clear about what you want to have done is going to be critical for you. So one of the things that I know Jerry had put together is this post-divorce checklist to make sure that people have a kind of a checklist to be able to follow in order to make sure you've kind of looked at all the things you need to. So, we talked about the divorce decree and making sure that you understand that. And Jerry, I don't know if you've seen any different things. Do you have any anecdotes about things that you've seen about out there in terms of issues around estate plans at all? Putting you a little on the spot there.
Well, I did have a situation where the woman died before the divorce was final. She was in the NICI period and she died. And the whole purpose of the divorce was it was a very different situation. The woman was old. I think she was in her 80s, and she had children from a prior marriage before she married her husband, who was also older. But he had his own children. So when they got married, they didn't keep anything separate. But now as she was aging, I guess her children wanted to make sure that they got a piece of the estate, because they knew that she was going to die before he was. And we filed for divorce in order so that she could leave her portion of the estate to her children. However, she died before that became possible. And that was upsetting to me, because I felt like, if she would have held on a little more, it would have been a lot different. But we also had a situation here where the husband was very sick. We represented the wife. The husband was very sick. It was a very hotly contested divorce. And he had children from a prior marriage, but he had a life insurance policy. And he became very ill very suddenly. And he changed the beneficiary on his life insurance from his wife to his son. And the life insurance company, it became we had to go to federal court over it. The life insurance company was saying, no, this is who's listed as the life insurance, the beneficiary, not the wife. So the probate court had one opinion about what should happen, and the federal court had to figure out who should ultimately receive. And I think it was like $1 million policy. And I think ultimately it was my business partner that had this case. But ultimately, I believe they were able to reach an agreement. But
right.
It was,
but the time, the expense, et cetera, having to go through getting that. So
it went on for a while.
Yeah, these things can happen. And when you're talking about the situation of the individual passing away before the divorce was final, in terms of the eyes of the law, there is again a claim that the now, ex-spouse can make against the estate to be able to get a share. So, the desire that things may then go to children from a previous marriage, or even children from the same marriage, may not be upheld, and a portion of the estate may be required to go to that ex-spouse. So, the outcome can definitely be something that you didn't intend.
There's a couple of questions actually in the chat box, if you can take those.
Sure.
One of them is, would the parent that has custody of children and is receiving child support still typically have the ex-spouse beneficiary on life insurance, or only the one who does not have custody?
Typically, if it depends on the finances of the party. So if the custodial parent doesn't work and it would be expensive or burdensome to get a life insurance policy, then typically that party would not need to get one. But where both parties work, even if you have custody and you were to predecease the other parent, that other parent's expenses are going to increase, because now that other parent will have the children more. So typically there are reciprocal life insurance policies put in place. The custodial parent usually has one that's at less value, because you're providing you have the children more. And so if you were predeceasing the other party, then that party, sorry, I jumbled that up a little bit. So typically you would both have life insurance, but again, it's a case by case analysis, depending on several factors, including what the incomes of both parties are.
Okay. And then the other question is, what if husband is a beneficiary of a family revocable trust and the wife is also listed as a beneficiary, and both spouses had been receiving distributions for over 10 years? Is the wife still entitled to payments or compensation either from the trust or the ex-spouse?
So from my perspective, these questions get a little, they get definitely very cumbersome, in the sense that one of the things we have to look at is, if this trust that the monies are coming from is a revocable trust, and the grantors, the creators of that trust, who hold the revocation rights or the amendment rights in the trust, have the ability to amend the trust regardless of the situation, they could amend you know, and I'm presuming this is, let's say it's coming from the parents of the husband in this case, and it had provided for both the wife and the husband, and the parents decide, you're not my son's spouse anymore, we're going to cut you out. If they have the right to amend that trust and they're competent to do so, still alive, then they have a right to amend the trust and remove beneficiaries. At least that's how I see that revocable trust situation. But I do know that there are times when a trust has been established, and let's say now the parents are no longer alive in this situation, and so no one has the right to amend or revoke. Well, in that case, I would argue that the wife still will get her beneficial interest because she is a beneficiary of that trust as it exists. I also see, and Jerry, you may have more to say about this, we from an estate planning side will oftentimes be representing the parents, the grandparents, the older generation in something like this, who have provided for their children and, you know, have helped to support their children over the years. And now the child and their spouse are getting a divorce, and they, the soon-to-be ex's attorneys or whatever want to gather information about the estate plan of the older generation so that they can take that information into consideration in determining how assets will be eventually distributed. And so we often work with them, and I can tell you from my older clients' standpoint, they get very indignant in terms of having to share in any way the estate plan that they may have. And there are some things that we oftentimes can do with the older generation. Again, if it is a revocable trust situation and they have the right to amend that trust, or they have some kind of what we call a special power of appointment within that trust and can redirect the beneficial interest, they may do so. And then we have to provide certain information to the court. It's called a Vaughan affidavit, and we have to put that together. But having said that, if there can be reasons why, if there was a benefit that was derived on a regular basis, et cetera, from another source, that can be taken into consideration in the divorce agreement. Isn't that true, Jerry?
Yes, I don't think that, well, I'll speak first to the older generation, and yes, they get very angry and they feel very violated if the spouse that they've been generous to during the marriage all of a sudden wants to bring them into the divorce and do discovery related to what they're holding. So as a way to lessen the burden, I find that the courts are not very interested in allowing the parents to be abused by the system or by the divorce. They will allow the parents, instead of being deposed or having to provide a lot of documentation, to provide this Vaughan affidavit, which basically says, this is what I hold, this is how it's held, this is what the party may or may not inherit, because that is something the court will take into consideration when making a final division of assets. What is the expectancy of future inheritances, right? So, but the court's not going to make, say Mrs. Smith used to give the parties a lot of money. The court doesn't have the power to then make Mrs. Smith continue to give the parties money. And things have a habit of drying up very quickly when there's a divorce that's been filed. However, the court may make the burden on the child who has these wealthy parents, such that indirectly the spouse who has relied on this money throughout the marriage still has a way of being supported, because they, throughout their lifetime or throughout the marriage, the parties relied on this money. Does that answer that?
I think so.
I think so as well.
There's another question. If there is a trust for the children, can you make the trust the beneficiary for both parents' life insurance policies?
Yes.
Absolutely. Yeah, I mean, the trust would have to be properly written. It would, there'd have to be considerations about what if circumstances change in the future, like, considerations about when that trust ends, about who's going to be responsible for managing that trust. Should it be funded eventually by a life insurance policy? So there's lots of thinking and kind of structure around that kind of trust that has to be put in place. But absolutely, if the parties agree, Jerry, wouldn't you say you could put something like that together?
Sure. And there's also, I think you would know this better than I, there's special life insurance trusts, aren't they?
There are irrevocable life insurance trusts that can be put together. They are irrevocable or irrevocable in terms of being able to change their terms once they're agreed to. And then they can be funded with life insurance policies, or even the policies can be owned by that trust as well.
Okay.
Right. Thank you. Those were all the questions for now.
Okay,
Excellent.
thank you.
So a couple of things I think we want to end, because we are getting close to the end of our time here, but I wanted to just follow through with a few things about the current laws that went into play in 2011 here in Massachusetts. We had brought in what was called the Massachusetts Uniform Probate Code, and it did have an impact on the family law area in terms of particularly estate planning. So one of the things that we saw, that if you have a change in your marital status, again, how it affects what's happening in terms of your estate plan. And typically this is things to know if someone doesn't make the important changes that they really should look to make, and that we have really, talked about so far. So let's say whether you were single and never married, or whether you were married and now divorced and remarrying, the new law, again, 2011, so not so new anymore, but did some changes. And one thing to know about it is that marriage used to revoke any prior will that you had in place. And so if you had put a will together while you were an individual and now you got married, it revoked it. Well, now marriage no longer actually revokes the prior will. So that's an important thing to know, that if you die and you have a will in place and you never updated it with your current marriage, again, the distribution of your estate could be something that you had not intended and not necessarily provide for your spouse the way you wanted to. Again, a spouse always has a right to a share of an estate, but it's not 100% right. And so, again, unintended consequences if you don't update your will. And if you have children from a previous marriage, when you get remarried, and you don't update your documents, the law no longer provides solely for the new spouse. It provides for both the new spouse and the children from your previous and current marriage, if you have children from current marriage too. So again, unintended consequences may occur if you're not updating your documents. Make sure your documents are really reflecting what your wishes and what your current situation is. And as things change, that you make sure that those are updated. You can enter into a will that contemplates marriage. You don't really like them, but you can do it. So, if you have to, if, you're planning a big trip, or, we have someone who is dealing with some kind of an illness, a diagnosis, and we're very concerned about how long they're going to live, and they want to create a will in contemplation of marriage, we can do so in order to provide for what you hope to be your new spouse. I don't know, Jerry, if you have anything to add to that at all.
No, I think that's pretty comprehensive.
Excellent. And the other thing to know is that under the current law, divorce has now changed how estate planning documents are looked at. So again, you put a will together while you were married, let's say, and you provided for your ex-spouse in that will, your now ex-spouse in that will. A divorce will actually remove, or actually doesn't remove the spouse. It will take the spouse away from being in an important fiduciary position. It will also take the share that you had left to that spouse away. It will revoke it. But that can have a very unintended consequence. So let's say you have a will, a typical will. When you were married, you provided for your spouse completely, and then you provided for your children. And now you have divorced, you don't update your will, you pass away. The will no longer provide for the spouse because that aspect of it has been revoked. Everything will now go intestate. So in a situation in which you just had children between the two of you, well, the children will end up benefiting, which is normally what you had intended anyway. But if they're minors, this might become a complication because we now have to take extra steps to protect that minor from getting their share outright. We need to make sure it's protected in some way. And if you have children from multiple relationships and you never updated the will when you left and it now goes intestate, there may be very different consequences about how your children, between the children of the marriage with the spouse you have divorced and children from previous relationships, are treated. And so that's really important to understand why updating the will and making sure that your wishes about how the beneficiaries are going to receive their interest be put in place, because the consequences of it happening after a divorce with no update and you're passing away can be pretty dire for those who you may have otherwise provided for. So it's very, very important things to consider. So I want to just quickly go through, if I can, and Jerry, please jump in where you would like, in terms of just some essentials I wanted to provide for you all about estate planning and the things that you need to think about. There are really, 5 basic documents and then a little bit about trust. The 5 documents start really with a durable power of attorney, which is a document in which you name somebody to step into your shoes to manage all decision-making for you but your health care. And it is a document that really provides a control in the financial world to be able to pay your bills, get at your bank accounts, do everything with respect to assets that you hold and accounts that you hold. And again, critical that you make sure that you have named what we call the attorney in fact, and that that person be somebody who you trust and who you want to be in this critical position of handling your finances for you. And this is the one that you don't want, oftentimes, the ex-spouse to be the one who steps into your shoes. Now, remember, this document's only applicable while you're alive, but if you become incompetent or incapacitated. So it's only effective during your life. Critical to have that put in place. Same thing with healthcare related documents, the healthcare proxy, kind of like a power of attorney, but for healthcare decisions, in which you're naming somebody to make healthcare decisions for you in the event you're incompetent or incapacitated. Again, it has a very broad base of authority in it. It allows for the use of antipsychotic medications, the admission to facilities if necessary. And so you need to make sure somebody who you trust and who you feel would be the best decision maker for you is named in this document. Living wills, they tend to not be documents that name anyone. They're more statement documents that talk about what you want to have done should you be incompetent or incapacitated with respect to your healthcare decisions. Not legally binding in Massachusetts, but they provide direction to your healthcare proxy. Another document to consider is the HIPAA authorization and release form. That is where you're naming people who you would want to be part of a conversation about your healthcare. And be able to give them permission to share information about your healthcare with your providers. Again, critical that you make sure that the people you want named are in this document.
I have a question.
Absolutely, go ahead.
Sorry, if you give somebody your healthcare proxy, do they then need the HIPAA form as well?
So the reason that we do HIPAAs on top of it is that the healthcare proxy only becomes activated upon your incompetence or
Okay.
incapacitation. So we do a HIPAA just as a catch-all in case, again, the healthcare proxy hasn't been activated yet, but you want to make sure these people are part of a conversation about your healthcare wishes.
Got it. Thank you.
Right. No, thank you. We've talked a lot about the last will and testament, making sure that your will document is updated given where you are in your life and the circumstances around what's happening. And certainly what you put in place when you were married is very different oftentimes than what you would want to put in place post-divorce. So making sure that you have named the people you want to manage your estate and you're clear about how you want your estate to be disposed. Remember, a last will and testament is only effective upon your death because it can be changed, updated by you at any time, as long as you're competent to do so. And the last thing to really look at are trusts. I really kind of focused on revocable trusts, but if you have irrevocable trusts, if they do have any ability to be able to change their terms, you really want to look at all of the documents that were part of your estate plan prior to the divorce, or if you had no documents in place, that you get them in place at the very least after the divorce to make sure they're reflecting your wishes. So we hope that was helpful to everybody. I don't know if there are any other questions that people have.
There are not any questions, just a comment about trying to make sure you take advantage of any employer short or long-term disability insurance. That's something to think about.
That people should think about. Absolutely. Jerry, thank you so much for sharing your wealth of information with us today. This has been, I hope, very helpful to people, and we appreciate your joining us.
Thank you so much.
All right. Have a good day.
Thank you, everyone.
Thank you.
Bye-bye.
Take care. Bye now.